Good afternoon, everyone, and thank you for joining us. My name is Louis Teck Hyong, Vice President of APAC at the International AI Safety Commission, and it is my privilege to moderate today's conversation. In my work, I spend a great deal of time thinking about how organizations adopt AI responsibly, and there are a few functions where that question matters more directly So So it is a genuine pleasure to bring that lens to this room today. You are joining the Legal Tech and Document Automation Summit, Singapore edition, brought to you by Tech Summit. Over the next hour, we bring together a big number of general counsels, legal operation leaders, law firm partners, and technology innovators from across Singapore and the wider APAC region for a conversation that matters. Artificial intelligence is no longer a question on the horizon for the legal function. It is already reshaping how contracts are drafted, how risk is assessed, and how legal teams are expected to show up as strategic partners to the business. The organizations that gets this right will move faster and with more confidence. The ones that do not will find themselves managing risk they did not see coming. That is exactly why we have assembled this room today, not for theory, but for a candid practitioner-led conversation on what is actually working, what is not, and what senior legal leaders need to be thinking about right now. Before we dive in, one quick note. This is meant to be a conversation, not a lecture. So please keep the questions coming in the chat box throughout the session. I will be watching it closely, and we would love to bring as many of them into the discussion as we can. Now, here is what to expect. We will open with a focus session on balancing innovation with risk in legal AI deployments. From there, we move into our main panel discussion, where 4 senior legal leaders will unpack how AI is reshaping legal operations, risk, and business strategy. We will close with key takeaways you can bring straight back to your own teams. Let us get started. Our first speaker, who's delivering the keynote, sits at the intersection of innovation and governance, which makes him exactly the right person to open this summit. Lyndon Xiao is Group Head of Legal and Compliance at ADDX, where he is responsible for guiding legal compliance strategy across a business built on financial innovation. Few people are better placed to speak to the real tension every legal leader is navigating today. How to move fast enough to capture the value of AI without moving so fast that risk and compliance are left behind. And just for confirmation, all speakers here will be speaking in their personal capacity. So Lyndon will be speaking to us on balancing innovation with risk in legal AI deployments. Lyndon, over to you.
Thank you so much, Teck Kyong, and good afternoon, everybody. Thank you for having me as the keynote speaker for Tech Summit's inaugural event in Singapore. I'm Lyndon. I head up legal and compliance here at ADX, which is a private markets exchange regulated in Singapore. So in the next 20 minutes or so, let's talk about balancing innovation with risk in legal AI deployments, which, in other words, is really trying to divine some sort of golden scales on which to balance innovation on the one hand and risk on another. So as I was putting this together, I realized this may be something of an impossible endeavor, but endeavor I will nonetheless to share perhaps some insights that you may find useful as you navigate the journey of implementing AI in your respective organizations. Now, I was very impressed by the list of attendees today. We have general counsels, law firm partners, and even some legal technologists. So I think it's safe for me to assume the sophistication of our audience today. You would probably know what a large language model is and how LLMs are probabilistic rather than deterministic. I'm also not going to discuss whether we should be using these tools because the reality is that our people already are. The real question I think we're going to try to answer today is on what terms really we should be using these tools. So one moment on this slide, right, which is the two sides of the scale. The first side, you have innovation. And I want to, start with this because a talk about balancing risk that only ever talks about risk, that's not really answering the question, is it? And on the left, I think we have some examples of, upside of implementing legal AI that, we might get in our organizations. And I would insist on actually identifying these gains rather than simply asserting them. That might be something you want to think about as you roll out AI in your organization. So just, from the top, we have first pass reviews, you're thinking NDAs, routine portions of a contract, which can now be turned around in hours instead of days. First cuts of a data room for those of you doing M&A and fundraising, or just summarizing a long consultation paper from regulators and other government ministries, right? And on the point of coverage, if you deploy AI well, you could potentially have a 2-person team advising as if they were a 4-person team. So it's a real force multiplier if you can use it well. But then we come to the real test, which is probably the most useful line on this slide for anyone who's being pushed to adopt something. That if the gain cannot be articulated, there's really nothing to weigh. And in that case, the answer to whoever the requester is probably going to be no. But it's no, not because AI is itself dangerous, but because there is no proper justification, right? And with that in mind, if we look at the right of the screen, what a blanket prohibition actually costs the organization, we set out over there. It's not really a neutral option to say no. There are real costs to saying no. And one very immediate cost is that people are going to start relocating their use of AI onto their personal devices and their personal accounts, where you and the organization are going to have no oversight and no audit trail. And if you say no, you're probably also foregoing gains that your competitors who are saying yes are enjoying. And on the third point on talent, junior lawyers now arrive already trained on AI tools, right? Many of them are AI native, and they do sit up and notice which employers or which bosses forbid them from using these tools. To them, this is a little bit like forbidding a carpenter from using power tools. It sounds ridiculous nowadays, but there are similarities in those two examples. So understandably, the AI native junior lawyers would be quite frustrated if they constantly told not to use AI. So really, both sides of the scale need to be properly loaded before you can meaningfully conduct, I think, your balancing exercise. And I think it bears saying as well that when people come to legal, they typically expect a correct or at least defensible answer 100% of the time, meaning that the processes which sit behind our work product must be deterministic in nature. And Gen AI, being a probabilistic tool, is sometimes ill-suited for a deterministic task, unless the user really knows how to use it. And I suppose that is the point to which I now turn. So I've structured our session today around 3 big questions, and they're on the screen. So rather than read them to you, let me tell you why it's these 3 and not other questions. We have a pretty diverse set of industries being present today. You have commodity and energy traders, you have aviation financiers, funds, family offices, insurers, a couple of foundations and law firms, and a fair number of in-house teams from tech, right? So very different businesses, very different risk appetites. But Yet, every organization here, I think, is answering these same three questions, right? And the first is really about getting your own house in order. And we're talking about our own people, our own data, our own supervision over our people and data. This is the question I think that we control the most, but we sometimes examine the least. Now, the second sits at the boundary of the organization and the wider world, right? And what I mean is, when a vendor is in a picture, the risk actually stops being something we manage internally and it becomes something we allocate between parties, which is quite a different discipline. And there are ways to handle this, I think, beyond just contract negotiations. And the third one, I think it's something that will sit with us for some time. This is on privilege. And privilege is something that gets decided by courts. So if we look to the slides now, the left column is the organizational hub, right? And here we talk about having things like approved tools, which preferably should be named rather than just described generically. Because frankly, while in conversation we bandy about phrases like enterprise-grade AI tools, that's not really a rule that anyone can apply in a robust manner. So instead of just saying enterprise-grade AI tools, you might want to name the specific tool that your policy is allowing or disallowing. And then we look at guardrails and parameters, which essentially are your do's and don'ts. For example, your policy could say that no input shall contain proprietary or personal data, and that sensitive inputs should be redacted appropriately before they go anywhere. And then we get to accountability, and really, if there's only one thing you take away from this session, let it be this. The organization and the individual remain responsible for AI-assisted work, right? And it's never a defense to say that, oh, it is the AI who gave me this piece of wrong information. Well, tough luck, right? Because liability in, I think, almost all cases would still sit with you or your organization. And then we turn to the right column on the screen, which is, I think, how we might control the employees and what you should get each of them to do, perhaps. Before first using it, it's often quite good discipline to read the terms, even just briefly. But the portions to zoom into are really things like data retention, model training settings, and discrete posture, right? It helps if the vendor has already in place cybersecurity standards like SOC 2, ISO 27001. But the reality is that most end users have never really done this. And even if you have it in your policy, they may still not do it. They think quite naturally that, oh, my legal and IT teams have already considered this, so, perhaps I don't need really to care. But it is precisely because we know this is the attitude or this is human nature that the organizational safeguards on the left of the screen become all the more important. And the next thing you may want to tell your users is that before relying on the output from AI, please verify the output and calibrate also how much effort you do in verifying, depending on what's at stake and whether you can afford to get things wrong. So, for example, if you're asking a Gen AI tool to prepare some slides for your internal team meeting, probably an error here or there you can live with. But if you're preparing some responses to a regulator, then you better make sure that you dot the I's and cross the T's. And no matter how tempting it might be, please don't just blindly copy and paste the output from whatever AI tool you're using. Now, when I say it out loud this way, it seems obvious, right? But the problem really is not that we lack these rules, is that they sit often in a policy document, on some SharePoint that nobody reads, nobody cares about, or just conveniently ignores. But really, when we are talking about policies only work when Policies only work when people can tell what the policy applies to, right? So one good practice, I think, is to classify the different types of inputs before the tool even sees the input. These 6 classes on the left, I think, are pretty generic classes that you can probably employ in your organization in some form or another. But each class of information attracts different consequences. It's very convenient, I think, to just say, for example, that no confidential information whatsoever is to be uploaded. But as a single bucket, that's a little bit too blunt, especially for legal practitioners and legal departments, right? So just going down the list, personal data, I think we're all quite familiar with, and we are all quite concerned with, because this engages the PDPA in full in Singapore. And that's one of the major sources of compliance overhead, right? And then on the second one, confidential information. These are information that carry obligations of confidence, but it's not necessarily only your own organizations. It's often also other people's where your organization is the receiving party. And I will make a point about material non-public information here as well. For those in financial institutions, this bunch of words may send chills down your spine because of how sensitive this may be, right? Privileged material, I think this is something we'll talk about in the last segment as well. And then commercially sensitive items like your trade secrets, your internal know-how, your precedents. These are all different categories of information. And then we look on the right, which are 3 questions on how I put to any tool before approval, which is essentially, does it retain what we enter, for how long this information is retained, and is our input used to train or improve the model? And finally, I think on data retention, data transfer, does it leave the jurisdiction, and can anyone else reach it? So I want to take a few moments to highlight a fairly recent case, right? Some of you may know this. The New York Times was suing OpenAI, and I mean, the long and short of it is that the court ordered OpenAI to preserve and segregate the output log data, which is to say all the chat data, regardless of what it had committed to consumers in its own policy, right? OpenAI challenged that order, it lost. And I'm not raising this to alarm anyone about a particular vendor, but it's a more structural point that even if you have a deletion right in your contract, it's really just a promise from the vendor rather than a guarantee or right against the world at large. And all it takes is a court order to render that sort of nugatory. So just on personal data quite quickly, I think we are all quite familiar with the sort of framework we have in Singapore. And also the PDPC has quite helpfully set out some advisory guidelines on the use of personal data in Gen AI just earlier this year, right? And those on screen you will see are 5, obligations when dealing with personal data. And just very quickly, you have the purpose and minimization. You need to be specific about the purpose, whether it's just training a model or for specific output. Those are quite different purposes, and how much personal data is justified is quite different, right? Notification and consent, this is also standard. Express consent is usually the gold standard. So where possible, please seek that from your users. And protection, right? So you have your reasonable security arrangements, retention, training, data transfers, what we talked about earlier. And then all the way at the bottom, accountability, which again talks about your internal controls, who's responsible, and so on and so forth. So none of these obligations are new, but what is new is how easily these tools let us breach each of these 5 obligations, one prompt at a time. And the sort of panacea, I would say, to all this is really human oversight, but human oversight that is proportionate to the task, right? On On the left, you have things like literacy. So it's really as simple as that people understand what the tools do. Responsibility, understanding that, again, I know I keep saying this, but it's important, that the responsibility remains with the person or the organization, right? And on proportionality or proportionate review, you shouldn't be spending 2 days reviewing internal slides prepared by an AI, right? But again, to use the earlier example of a regulator, you wouldn't be copy pasting the output either, right? And just on the last point on unfamiliar ground, when you're pushing something out that you're not familiar with, that is when I think some additional scrutiny is warranted and required, because it's difficult to see and identify the blind spots if you're not familiar with the area. On the right, just quickly again, you have your escalation protocol, right? So you need to clearly define what your triggers are for escalation within your organization, and the pathways for such an escalation. If, for example, there is some input that a particular employee doesn't know whether he should be uploading or not, there should be a clear path of escalation to perhaps his manager or even senior management or even legal departments as necessary. So agentic AI, I think we have heard quite a bit of it, but you can essentially just think of it as AI that acts, right? Rather than just a chatbot that answers your question as you prompt, it acts on your instructions and your prompts, right? It generates data or generates output after looking at data, and does so in a somewhat autonomous fashion. So obviously this increases the risk profile, and how it increases the risk profile is that it is essentially allowed to do certain things and take certain actions of its own accord. The problem, of course, is that no matter how good your prompts are, there's a risk of hallucinations and the risk of the AI sort of doing more than it's expected to do or is being instructed to do. But again, the responsibility sits with the organization and it sits with you. So this is something that you need to consider carefully before rolling it out. And I think we have seen in the reports of the cost of unverified output, right? These are reputable organizations that have been found to be using output from AI that wasn't verified and was just plain wrong. And the reputational damage is quite massive. These are ongoing matters, and only time will tell how they would resolve. But I'm sure none of us would want to be caught in such a situation. So please think about this a little bit more. On the second part, which is on vendor due diligence, I think we should have an idea of how to handle our vendor contracts, right? So I think we need to scope, if we look on the left, what is the role of the vendor, right? Are we just looking at a model provider or system provider? Is it a SaaS? Is it an API? Again, it needs to be tailored, right? And then we look at what data is being uploaded into the tool, what is being processed, followed by whether the vendor has its own dependencies, right? Whether downstream its subcontractors adhere to the same standards and the same make the same warranties as they have to you. Security and operations, we've covered this in a little bit. Your security standards like SOC 2, so on and so forth. And just on the last point, which is on residual risk, what happens to your data after you terminate the contract, right? Whether there is a right to demand that your data is deleted, and whether there are ways to enforce that right are also things that you would want to pay attention to. So in the interest of time, I'll just talk about the golden rules, right? Which is when you are reviewing a contract, I think one golden rule, the first golden rule is to really read everything. I know it's easier said than done, but it is important, right? You have your master agreement, your statement of work. the order form itself, data processing agreement, so on and so forth. And together, just because you have negotiated a data use right in one of the documents doesn't mean that there isn't another document that cuts across that right that you have just so painfully negotiated. So this is a trap that often catches out some in-house counsel, right? And second would be to weigh actually the risk against your own leverage, right? If you're talking about a tool that essentially all organizations use, right? Say Microsoft solutions, then you probably wouldn't be renegotiating most of the terms. But if you're talking about something a little bit more bespoke, a white label solution from a smaller vendor, for example, then it might be a good idea to look a bit closer at that. Now, just on the final part, which is on legal privilege, right? And I saved this for last because it's sort of an open point. I think there have been a few cases around the world where, you know, if you look at the left, there was a UK tribunal that held that uploading confidential documents to a public AI tool is essentially putting it in public domain, and therefore it loses its quality of confidence, right? And certain Australian courts have made the same comment. But if we go towards the other side of the pond, the American courts have actually been quite split on this, right? One court held that documents prepared using a chatbot were not privileged at all because the tool wasn't a lawyer. But another said that essentially if it's, you know, enterprise grade AI with the appropriate safety, security provisions, data retention, training provisions, then in that case, it was fine. So in Singapore, unfortunately, there's no clear guidance from the courts on this yet. And I suppose only time will tell. But as in-house counsel, I suppose it would be good to take a more conservative approach, unless you're sure that you're dealing with a proper enterprise-grade AI solution with all the bells and whistles, the appropriate protections. You should tailor your policy to make sure that data is not inevitably or inadvertently uploaded, which results in a breach of confidence and a loss of privilege. So just some practical takeaways before I close, right? And none of these, need a budget. You don't need additional headcount. So one is to really name the tools, right? A one-page policy that approves and prohibits the tools by name with data rules attached to each of them, and this can be done quite easily. And in fact, some of my counterparts have quietly whispered to me that they actually use Gen AI to draft their Gen AI policy. It's a bit ironic, but there's nothing really wrong with that, so long as the output is verified. And it's always better to have a policy than absolutely nothing at all. The second is to ask every tool 3 questions before approval, right? Which is retention, training, and location, right, of data. And you should record the responses from your vendor. And if the vendor doesn't respond, that in and of itself probably is the answer. 3 is to put the appropriate escalation triggers and to upload the runbook in writing, right? So if you have a high risk use case, this has to be escalated. And if there is an inadvertent upload of confidential information, this should be escalated as soon as possible within the same day, so that we all can jump on it and assess what the impact is on the organization. And the last one is really, again, to read all the documents before you actually sign the full suite. Don't take a shortcut and just read the main document and not all the referenced documents, because there are traps hidden in those documents, right? So just some thoughts before I close. I think over the course of the past year or so, every other week there's a new white paper, a new guidance note, or just some other headline, right? All talking about AI. And you probably felt a bit of whiplash just trying to keep up, right? In everything I covered, the policies, the oversight, the contractual provisions, rules on privilege, the golden thread really is that accountability never moves away from the organizations and the humans running it. The tools have become very, very powerful, and the new guidance keeps coming. But whatever the tools do, the buck still stops with the organization and its leadership, right? And that's most of you on the call today. And I think that's a feature of our jobs, not really a bug. And it's in essence what we're paid to do, right? Exercise judgment where there is a fog of war, exercise judgment when perhaps things are not entirely clear, and to allocate the risk and to manage the risk in all organizations. So with that, I've come to the end of the keynote speech. I just have over here my LinkedIn contact. Very happy to connect with you separately or even in person over coffee. Thank you.
Okay, thank you very much, Lyndon. That was an excellent key presentation. And if I may just summarize it very quickly, it reframes AI risk in legal work from a technical challenge to a leadership accountability. The core message is that AI doesn't change the rules, it makes them easier to break. And we must balance the promise of innovation against the real risk to confidentiality, privilege, and liability. The solution isn't paralysis, but proactive governance. Name the tools, classify the data, and verify the output. And crucially, you must build oversight from policy to contract to privilege. Remember, the accountability for what these tools do never moves. It still stops with the organization and its leadership. We are actually running out of time, but perhaps I could just give one question. Lyndon, and this is from Lena Kreiber. When deploying AI into legal workflows, how do you decide which decisions can safely be automated and which decision should always remain with a human?
Sure, and thanks, Lena, for that question. So I think I alluded to this in my presentation earlier, that I think as a legal leader, senior legal leader, you would have to triage this quite carefully, right? It is a proportionality analysis, right? The high stakes decisions, the decisions that you really cannot afford to get wrong, those you would have always sit with a human being, right? Or at least have a human oversight over this. The lower stakes, tasks, perhaps, just getting a tool or an agent to look through your inbox and sort of give you a summary of outstanding items. That one you can probably delegate and sort of automate away, right? With minimal risk or minimum consequence if it gets something wrong. So proportionality, I think, is the key.
Okay, thank you very much, Lyndon. Unfortunately, we have run out of time for this session, and we'll have to move on to the next session. But please do scan the QR code for Lyndon and follow up with him on the questions that the rest of you may have. So now we move into the centerpiece of today's summit, our panel discussion, titled Beyond the Hype: How AI is Reshaping Legal Operations, Risk, and Business Strategy. We built this panel deliberately. Legal AI does not look the same from every seat in the room. And if we only heard one perspective today, we would be doing you a disservice. So joining me are senior legal leaders spanning law firm, practice, in-house counsel at a global trading business, and legal and compliance leadership within capital markets, each bringing a different vantage point on the same set of questions. I will introduce them very briefly before they start in their respective 10-minute session. So please join me in welcoming our panel: Joanne Hui Hian, Legal Director of Clyde & Co., Ho Fu Ang, Senior Legal Counsel, Toyota Tsusho, Clemens Keng, Head of Legal and Compliance, Singapore JAR Capital, and Frederick Grissel, Head of Legal, AGP. We'll start off with Joanne Hui. She is a legal director at Clyde & Co., who acts in complex litigation and arbitration across high-stakes disputes, including major infrastructure and construction matters, engineering failures, insurance coverage disputes, shareholders' conflicts, commercial disputes and insolvency, and restructuring proceedings. She regularly navigates large volumes of evidence, expert reports, and competing legal theories. Her perspective is informed by practical questions, not simply whether AI can produce an answer, but how lawyers can use AI to produce defensible outcomes that withstand scrutiny from clients, opposing counsel, experts, tribunals, and courts. So, Joanne, the first question to you is, what is the one thing AI is doing in your legal work today that you would confidently put your professional name behind? And one promise about legal AI that has proved much less impressive in actual practice. Over to you, Joanne.
Yes, thank you very much, and thank you, Teck Hyong, for the very nice introduction of myself, and Lyndon for the very enriching presentation today. Yeah, so for me, because I am primarily a disputes lawyer, I use AI a lot to help me to craft better arguments. So what I found through the years is that I really rely on AI to help me spot check my answers to see whether there's any other angle that I haven't thought of. And because the kind of work that I do, dispute space, it's very sensitive, right? You actually have to come up with arguments that withstand the scrutiny of the courts, of your opposing counsel, of the tribunal. So you can't afford to be wrong. Like if you're wrong, you lose like millions of dollars. So AI is very good in suggesting to you what you might have missed out on, what you else you might want to consider, how the tone sort of like how the tone sounds, and maybe you wanna draft it in a different way, for example, to get the point across and to make it more persuasive, right? So this is AI really being used to sort of improve the arguments and make it more palatable to whoever the reader is. And I find that this is a really good use of AI. This use of AI, however, comes with a lot of strategy and the ability to give a proper sort of judgment on the kind of output that the AI has. And it depends a lot on the kind of experience that you have, the kind of cases you've dealt with. So I'm not really like a motor insurance lawyer, right? So if the AI tells me that, oh, if I have this accident and then if I make this argument, it's going to be better, I really wouldn't know whether it's really going to be better or not. So a lot of the use, therefore, and the benefit of it, therefore, only comes when the user, him or herself, has got sufficient expertise to decide whether or not the AI is useful or not. One aspect that I find that AI has not really been delivering, although AI has marketed itself as being that, is to completely replace the junior lawyers doing what we call grunt work, right? So, for example, we would frequently employ junior lawyers for large disputes, and then they would perhaps go through the evidence, do discovery, they would prepare chronologies, read through the evidence, the documents, draft first cuts of advice. And we find typically that when the junior lawyer sort of like AI just cannot reproduce this thing entirely, because you still have to check through everything. And when you have to check through everything and it involves volume kind of work, then you are just taking the same amount of time to check through the thing. So it's not a like for like replacement.
Okay, thank you, Joanne. Perhaps I could follow up with a question. There is an important difference between AI producing a plausible answer and a lawyer producing a defensible legal outcome. What must happen between those 2 points? Where must the lawyer personally retake control?
Where must the lawyer personally retake control? I think the AI can suggest to you answers, like what I've said just now. They can suggest to you some answers, and then you can sort of look at it. And then most of us who, if we don't practice or we're not specialists in a certain area, we'll really be like, okay, I'm not very sure which is correct and which is wrong. So my clients, they'll always come to me and they'll say, oh, the AI said this and that, but I don't know lah. I mean, you are the lawyer, so you tell me which one is the correct answer. And that's why I'll tell them, okay, as a matter of practice, it works like this. This argument is unlikely to succeed, although the AI says it can, you know. And so I suggest you do it this way. So it's really, I think it really comes down to you still need a professional or human actor to verify the AI suggestion and tell you when the AI is wrong. Also, just a thought came to my mind that when you're really doing like high stakes litigation and you're relying on the collective wisdom of the internet, it's not going to help you very much if you're trying to come up with a novel argument. So that doesn't really help much. Yeah.
Okay, if an AI-assisted submission contains a hallucinated authority, and this also relates to one of the questions that were posed in the Q&A chat box, misunderstands a critical document or generates an argument that does not withstand scrutiny, who ultimately owns that error? It's a very important question in practice at the moment. I'll really be grateful for your views on this.
Yeah, okay. So I think the courts all over the world have said that the lawyer owns the mistake. And then of course the senior lawyers around us, we would be like, oh yeah, the junior should have checked, right? Too many mistakes, too many hallucinations. But ultimately, when you are the one who's the barrister or the advocate in court, the judge is scolding you, not your junior or your team, right? Actually, the Singapore courts, they have prepared this document called a guide on the use of generative AI by court users. And basically, they say that generative AI is a tool, and any output generated should only be used on the basis that the court user assumes full responsibility for the output. So, the lead counsel, right, and his team of lawyers will assume responsibility for any outputs and any mistakes.
Okay, so in closing, what is the one thing a disputes lawyer should never delegate to an AI?
Um, I think a disputes lawyer should never delegate document review completely to an AI. I mean, if there's too many documents, then you just need to spend more time doing it. Or you get a junior to put it through the AI and then get the junior to check through everything. Because at least if you ask the junior, he can tell you what he looked at and what he didn't, right? AI cannot tell you, oh, I missed out this, I didn't look at this, I looked at this, I put it all. Yeah. I mean, in fact, the AI will tell you I put everything inside, but actually, in fact, it didn't, right? So I think document review is very important because that's how we win or lose our cases. Research is very important as well, and ultimately the strategic input that will be mostly human. Yeah.
Okay. Thank you, Joanne. So Joanne has taken us to the standard. The final legal product must meet, but defensibility increasingly depends on whether lawyers themselves understand the systems they are using. That actually takes us to Hofu. So Hofu or Ang Hofu is a senior legal counsel at Toyota Tsusho Asia Pacific. And joining us in his personal capacity, he is also a lawyer who writes the code. So his open source legal codes runs at about 170,000 downloads a month. He was a named contributor to MinLaw's Guide on Generative AI in the Legal Sector. And when Harvey open sourced its legal agent benchmark, he ran it himself on models that can be hosted locally and publish what the scores actually mean. So he mentors practicing lawyers through the Legal Quants residency and writes Alt Plus Counsel. So Hofu, my first question to you is almost every lawyer can now open an AI tool and type a prompt, but that surely does not make someone AI proficient. So what does AI proficiency or becoming genuinely AI native actually mean for a lawyer?
Yeah, thanks, Taekyon, and thanks everybody for having me here today. So the question is, does being able to type a prompt mean that you're AI native? Of course not, because just buying a tool or just typing in a chat doesn't make you AI native. And you really need to use the tool in order to learn about it. And because doing these kind of things can be quite counterintuitive. I can tell from my personal experience. I used to write like, 3, 4 pages long prompts. And, according to a study, if you had did that, it actually reduces the effectiveness of your AI output. So, and this is especially true for frontier models like Fable and Fable. If you wrote very long, detailed instructions, it usually just gets in the way of AI becoming more powerful. Going back down to being a lawyer, I've always thought that, Lyndon talked about balance and things like that. What I feel, is that an AI native lawyer needs to have two things. One is they need to have professional judgment. So it tells us what a good legal outcome requires. And not only that, they also need to have AI literacy. So this tells them whether, how the system may fail, how to test it, in a sense, knowing how to evaluate the system. So yeah, an AI native lawyer maybe doesn't use AI for everything, but when he does use it for the place where it belongs, it makes his human judgment much stronger and produces great results.
Okay, so the legal profession rewards expertise, right? So AI presents the unusual challenge of making every experienced lawyer's beginners again. So what helps an experienced lawyer become comfortable experimenting, failing, and learning again?
Yeah. So thanks, Tae Kyung. Yeah, I know there's a lot of anxiety about this, but just because Gen AI came along doesn't mean it took away your expertise, doesn't mean it took away your experience. So let's be clear, what you're being uncomfortable with is a new tool, is a new instrument. So yeah, I'm glad you mentioned at the start that, I was involved in this mentorship program called the Legal Quants Residency. We're into our third cohort now. And what we do is that we accept senior partners and general counsels from all over the world. And what we do is we bring them to the frontier. And bringing them to the frontier means using the best AI tools out there. And in my opinion, and I think a lot of people's opinion, is cloud code. So, these GCs and senior partners, they are thrown to this console and there's like, where's the exit button? How do I send stuff in this thing? And, there's a bit of a learning curve. But, at the end of the mentorship program, when they produce a program, when they demo their product, if you ask them what they learned the most about it, it's not that they learned how to cloud code. They are thinking about bigger things already, like, bigger things like, how to roll out their product, how to, make their judgment become even more codified. Because, what helps experienced lawyers, I think, is to try it out, to become even more familiar with these tools. And, once you are more familiar, I believe strongly, and there's the experience of a lot of people I've come across that, it makes their human judgment, their expertise become even stronger and, much stronger than that.
Okay, you have built tools and tested models yourself. So does the best technology necessarily become the technology lawyers actually use? If not, what really determines adoption?
Yeah, that's a question I wrestle a lot with. In of course, if you're doing on a personal basis, you can choose whatever tool you want, as long as you have the money for it. And I know a lot of people who spend hundreds of dollars on this kind of thing. But, we live in organizations and organizations have restraints, have different personalities, and so on and so forth. So, what adoption means that, for somebody who's a lot more closer, who's more well-versed with the technologies, to find that easy middle that, everyone's comfortable with. Because what you're trying to do is not to show off that you're good with this tool or something like that. At the end of the day, we have a job, and our job is to produce results. And that results, comes in, triaging, which tool does the best work. And I think, once you have an idea of, how to make the use, to push it to its maximum, that is when adoption becomes more well received.
Well, you have also personally run a legal agent benchmark. So, what should an ordinary lawyer understand about benchmark scores? When are they useful and when can they create false confidence?
Yeah, thanks, Tae Kyung. So just to elaborate a bit for people who are not familiar with this, Harvey, maybe that name is more famous. But as part of their research, they released open source something called the Legal Agent Benchmark. So what this does is that you're supposed to run your model or your program against this benchmark. There are about hundreds of thousands of tasks to do, and then it will score it based on whether the agent is able to meet the standards that reach this benchmark. So, benchmarks are cool because, they give you a very nice, solid number that tells you how good or how bad this model is. So, for example, you've got Fable scoring the highest at some point, and then suddenly, Kibi or DeepSeek reaches that level, and then suddenly you think, well, what's going on here? And what's going on is actually, it's a test in the end. So, as Singaporeans and as lawyers, I think, going through school, in order to cheat at a test, you just have to modify things a bit here and there. And that's what I experienced when I run the test myself. For example, I ran the test with Gemma for this is Google's model. And what happened was that, the agent decided to write the legal document, but they wrote it in a different format, and this format wasn't recognized by the scorer in the benchmark, so it gave it 0. And maybe as a lawyer, as a human being, when you see that, you see the product, you see, oh, maybe a pass, but to a computer it didn't pass. So you have to take benchmarks with a pinch of salt, and ultimately you have to test with your own tools. So yeah.
Okay, in closing, perhaps I could ask you this question. What distinguishes a lawyer who merely uses AI from a lawyer who genuinely understands how to work with AI?
Okay, I like to say that it's obvious because an AI a lawyer who's used to the old methods, they produce like a Word documents and things like that, and they type out everything. But once you are well versed with AI, you know what they can do. You start producing more stuff. It's very easy to produce tables, statistical analysis, web applications, so on. So the palette of what you're able to show your client, but is definitely more impressive. And I think that there's one way that shows that you are an AI native lawyer.
Okay, thanks, Hofu. So Hofu has focused on capability at the level of the individual lawyer, but individual proficiency does not automatically mean an organization is ready to rely on AI. So Clemens, who will be speaking to us next, will take us from the individual adoption to institutional reliance. But before that, if any of the members of the audience have any questions, please feel free to just type it all in. I'm quite sure the organizers will give us extra time to address all the queries that you might have. So our next speaker, Clemens Keng, is Head of Legal and Compliance at JAR Wealth Management, where his responsibilities span legal, compliance, risk, and governance within a regulated financial services environment. He began his career at the Monetary Authority of Singapore, serving across 6 roles spanning economic policy, legal advisory, and banking prudential policy, before ultimately leading MAS internal policy on data and knowledge management. He subsequently held senior roles at Interactive Brokers and Fraxters, led the legal, regulatory, and compliance practice for Egon's Zender in the region, and has taught at university level. He brings an interdisciplinary perspective across law, finance, risk, governance, and technology. So, Clemens, people often begin experimenting with AI before the organization has a formal strategy or policy. At what point does individual experimentation become an institutional governance issue? Should governance begin by discovering what people are already using and where AI outputs are already entering business processes? Over to you, Clemens.
Thank you for the very kind introduction. I think the fact of the matter is, people is probably earlier than most institutions realize, right? It only becomes an institutional issue when organizations formally procures an enterprise platform or publishes an AI policy. That's really not the threshold. The threshold is crossed when individual experimentation begins touching information that belongs to the organization or third parties, entering a business process or influencing an outcome for which the organization is ultimately responsible or liable for. So I think a good heuristic is to look at three things. One is the use case, the type of information being assessed and used, as well as the consequences of the output. So on one end of the spectrum, using AI to brainstorm with public information is probably not going to be very, very serious that requires a lot of governance. But uploading client documents, connecting it to an email account, using it to assess customer risk, or even relying on it to draft advice or to make certain decisions can be very, very different. Unfortunately, governance often starts much later than adoption. In my experience, people do not wait for a 30-page policy or a memo to be disseminated before discovering tools that can help make their jobs and their lives easier. So when an organization finally asks what people are using, it may discover that actually for the longest time, AI-generated outputs are already entering its processes. That is why, in my opinion, and what I advise people to do is that one of the first governance exercises should be a discovery audit to try to figure out what tools people are using for what task, what kind of information are being put in, and where are the outputs going. And it's important to note that the purpose is really not to catch people out, right? It is to provide a safe, usable route for adoption, including then future approved tools with suitable confidentiality, security, and retention protections. So a prohibition without a practical alternative often just drives usage underground, and it may tick the checkbox, but it doesn't really help on a practical level. So ultimately, if the institution then has to rely on the output, it should inherit the governance question.
Okay, Clemens, you have said that human in the loop is not by itself a control. What must be true about that human? Expertise, information, mandate, and authority before oversight becomes meaningful rather than a rubber stamp. It's a pretty important governance issue in relation to AI. And we know we all struggle with it because it's one thing just putting human in the loop, but what exactly is the human doing, especially when AI is moving at lightning speed?
So yeah, it's certainly something that we have heard quite a lot, right? To ensure that there's a human in the loop or on the loop, and it has become a form of a reassuring phrase, especially for those of us in legal and compliance who may not be as technically advanced. But honestly, and I've said this publicly before, it tells us almost nothing about the quality of that control. Because a person that is clicking approve can be a rubber stamp before something goes wrong. And ultimately, for some organizations, unfortunately, that person then becomes a scapegoat afterwards when something does go wrong. So human oversight is meaningful only if a person is able and also expected to challenge the output of whatever AI tool is being used. And that requires, in my view, at least four things: competence, context, the time and the authority, as well as the placement within the process itself. So in terms of competence, the person that is placed in the loop needs to understand the subject matter enough and also understand the tool enough, which I think several of my other panelists, as well as Lyndon, has mentioned, and its limitations to know what exactly to question or what to look out for. And in terms of context, the reviewer needs to be able to get access to all the relevant document sources and surrounding facts, right? Rather than a polished conclusion that an AI tool then generates at the end. In terms of time and authority, we have to give our reviewers enough time still, notwithstanding that we are all trying to become as efficient as possible to test the output, but also be given, if possible, formal authority and power to stop or at the very least to escalate the process to someone with the power to stop the decision. And lastly, and very obviously, the person has to be placed within the process such that intervention can happen before the crossing of the Rubicon, right? They need to know and be able to stop anything before something becomes consequential or irreversible, not merely just after the event. And to me at least, the degree of oversight should reflect the consequence. If it's to use an example somebody else has mentioned earlier, if it's a brainstorming suggestion or an internal paper, it does not need the same kind of control as advice to a client, a regulatory filing, or decision that perhaps affects someone's physical bodily rights or private property rights. And this does not mean that I would advocate for inserting a person mechanically after every AI output, because that could add delay without actually really trying to help in any meaningful way to try to control risk. So it means identifying where the human judgment, at least at this point of AI development, genuinely still matters, and designing the workflow so that the human can exercise it. Because ultimately, at the end of the day, uh, the mere fact that there's a human present doesn't mean that there's human oversight over the process. Oversight still requires the four elements that I've mentioned.
Okay, suppose an AI-supported process nevertheless produces the wrong outcome. What evidence would demonstrate that the organization governed the risk responsibly despite the failure? So, that's a $1 million question for all organizations which have AI system which crashed. Then what other mitigating factors can they raise other than I did my best, under the law and under the systems and all that. What's your view on that?
I think this is a very difficult question to answer, and it's something that even for those of us who have looked into this at length, need to remind ourselves of from time to time, which is, it is true that there are certain activities that really require zero failure, or at least must be designed on the basis that failure is clearly unacceptable, and we should try to approach zero failure as much as possible. So I mean, even in the non-financial industry, we obviously expect extraordinary levels of safety whenever we fly on an aircraft, when our cars drive over a bridge, or in very topical in a Singapore context, if we are living near a nuclear power plant. And for those of us with an engineering background as well, we would have in our past lives realized those systems will contain multiple layers of redundancy, because it is obvious that the consequence of a single failure can be catastrophic. But even there, it is very well recognized that each additional increment of safety becomes progressively more expensive, to the extent that it may be inefficient to do so in terms of allocation of resources. So moving from 90 to 99% reliability is one thing, but the extra 1% can require disproportionately greater investment in engineering, testing, oversight, redundancies, and operational costs. Often that last 1% can cost more than the first 99% itself. And that is why, I've always been a big fan of the EU concept of proportionality. So proportionality matters, right? And this term has been used, I think, by some of my other speakers earlier today as well. So we should not impose, nuclear power plant controls on an AI tool that summarizes a publicly available document. Somebody in another conference mentioned this, and I think it's very, very true, that we shouldn't expect of an AI system a level of reliability that we don't expect of the humans that are currently performing those tasks. So if we expect that humans will have some mistakes, it is human nature that we fear something that we don't understand, and we should control for things because we perhaps are unable to fully quantify the consequences. But we shouldn't then also over-engineer and try to get something to a safety standard that we would normally not even expect professional lawyers to reach. So we equally, we shouldn't try to apply this kind of productivity tool controls where unless, to me, it's when they really affect somebody's rights, they are able to move money, they can disclose or use somebody's PII or confidential information, or to communicate, and in some cases, including I think with Air Canada, able to somehow give some form of legal obligation on behalf of the organization that was deploying the AI tool. So the required level of assurance, I think, should reflect both the probability of failure as well as the severity of and the consequences of that failure, right? Including whether or not those consequences can be reversible. And also then the organization's ability to detect and contain it after it has failed. So the other thing that I think we try to remind ourselves a lot on is we shouldn't or we should try not to judge our original decisions entirely only with the benefit of hindsight. A good decision made carefully using all available information that was reasonably available to us at the time can still produce a very bad outcome. And conversely, a poor decision can produce a good outcome just because you're lucky. So the outcome matters, and I know we live in the real world, so practically the outcome always matters. But that is not the way we should judge the decision-making quality. We should ask what the organization knew at the time. Did it correctly identify the material risk? Were the assumptions that we have used reasonable? The controls that we placed proportionate to the risk that were identified? Was responsibility assigned correctly to the people best able to mitigate those risks? And also, could the system be monitored, challenged, and stopped, especially when if we see warning signs? And again, after the failure, it is good to look at an organization and we can see how, in good faith, they have managed to not only detect and contain it, investigate honestly, remediate any harm as much as it can. And I'm not saying that we should excuse negligence, right? But this distinguishes a reasonably governed decision under uncertainty, and we live in a very uncertain world, from an unmanaged gamble that then happens to go wrong.
Thank you, Clemens. We'll definitely like to extend it further, but in the interest of time, I must move on to the next speaker. So Clemens has drawn the line between technical capability and institutional readiness. Our final question is therefore operational. Once you decide to proceed, what can a legal team actually implement? Fred brings us directly to that question. Fred Grisot is head of legal at AGP Group, a real assets developer with a significant data-centered development business. He leads a lean 6-person legal compliance and corporate secretarial function, supporting a cross-border business, and brings the practical in-house perspective on implementing AI with limited resources and budget. So Fred, if I'm a head of legal with a small team, limited budget, and no real AI strategy, what can I actually start doing on Monday morning? Why does your sequence, clean data playbooks, guardrails, access rights, contextualization, workflows, and only then more autonomous or agentic applications matter? Over to you, Fred.
Thank you, Tech. So I head up the legal team at AGP Group. We're an infrastructure developer, and under our businesses, we have a large data center developer. So it doesn't mean that we have access to our own rack of GPUs. So we have essentially the same access to the tools that everybody else has. To answer your question, I would not wait for Monday. I would actually already start playing around on during the weekend. And so I see that a lot within my team as well. People are a bit afraid to play around during their working time, during their office hours. And so the best thing is to literally watch YouTube movies, I would say, and download the desktop versions of, Claude and ChatGPT now as well, and play around with Codex and Code. Visit GitHub, see what's available out there. Don't reinvent the wheel. There's a lot of great, legal review tools already developed. Create your own Claude skills. So all of these things we should, as legal counsel, start playing around with. And to answer your question as to what should we do from Monday on is look into what you currently have in terms of legal tech tools, which features, and sometimes it's only a very few of them you're actually using, and which you can develop yourself. It's surprisingly easy, as most of us know, how you can develop your own tech tools these days. Frighteningly easy, I would say. So at our company or at our legal team, we're retiring some of the legal tech tools because we can simply develop them ourselves, and like structured chart tools and even EMS tools. And so we expect our lawyers, of course, in the councils to make use of the Harveys of this world. But when it comes to like really operational tools, we're doing that ourselves because we can tailor that much better than anybody else. So yeah, I receive constant marketing emails or kind suggestions from colleagues like you should use this and that. But to the risk of being blasphemed as a Luddite sometimes, I think we can develop a lot ourselves. But there's one I would say key condition for that, and it's clean data. And so a lot of the AI transformation is surprisingly boring, I would say. But the good news is even AI can help you very well with cleaning up your existing historical data. So we asked Claude, which works in dedicated folders, which is approved to clean up and reorganize, our data. We basically give it a certain context. You're a corporate secretary with 30 years of experience and an obsession for order, and you love coding during the weekend. And then we give it, a certain folder structure and naming convention. And so please rearrange and rename everything. Don't delete empty folders, put duplicates in archive, and it does it. And so that takes away a huge burden and a lot of the heavy lifting already in order to get to those automated workflows and agents, which is really the fun part.
Thank you. But there's a question in the chat box, which is, on the same theme. And if I may just read it out to you, it's from Laura J. For those with smaller legal teams versus larger ones, does having fewer people change how you approach adopting AI compared to teams with more headcounts? It's on the same question which I posed earlier, but it's slightly different in the sense that, I think probably the motivation is, having AI puts you on the level the playing field between small and big teams. Yeah.
No, exactly. It's a good question. I mean, each of those, whether you have a lot of team members or not, all of them need to transform into sort of AI legal engineers and process architects, I would say. And it's a change of mindset. And so you will be needed, but we can automate a lot of the repetitive tasks. So I would say we should automate everything around a judgment or around a certain decision. But obviously, the ultimate decision or judgment we cannot automate and should not automate. But so a lot of these in between tasks will be automated, and these tasks will disappear.
Okay, thank you. And where should the human genuinely remain in the loop? I mean, how do we avoid turning human in the loop into human in every loop, while still preserving the lawyer's ultimate judgment?
Yeah, it's a good question. Like ever since I read that book from Richard Susskind, The End of Lawyers, which is already 20 years old. It's incredible, but it also means that AI, in a sense, is also not a new thing because he was writing already on that. In 1989. So I've always heard that lawyers will disappear, and until now, I think there haven't been as many lawyers as today. So, but we'll definitely need to, change what we do and where we are being used for. And I think our job is to decide what we connect the model with, which is increasingly commoditized, what we connect it to. So you need to make sure that you have clean proprietary data, that your playbooks are in order, but then install the permission and the guardrails, something that has been mentioned a couple of times already. And then the context. There is you cannot commoditize context. You cannot commoditize or like automate personalities in a company, for example. So that's really what we're really good at. And then I think ultimately it will all be about the permission model. This is where the legal thinking really will survive and thrive. And so with that, I mean, what are the access and editing rights? What are the intake and approval processes, the audit trails, and really tailoring all of that to a very particular corporate and governance setup at AGP. It's a very particular setup with a group and various business platforms which all operate in a less or more independent, and a different stage of maturity as well. So that is something that you cannot find an off-the-shelf solution for, and so that's really where we need to come in.
Thank you, Fred. There's a question actually in the chat box, which is really in your area as well, by an anonymous attendee. Beyond saving lawyers' time, what metrics should a legal department actually use to determine whether an AI investment is delivering real business value? That's a big question here. I mean, everybody's going to go on board and invest in AI, but how do you know whether it's delivering real business value, meaning profitabilities and all that thing, and quick turnaround time?
No, I agree. I mean, it's not only for legal, right? It's impossible to determine the ROI on many of these AI investments. But I would not put it in monetary terms, of course, but within the legal sphere and the in-house sphere, I would say if there is less friction in the process, if we can get quicker decisions for the business, if I hear less complaints from business that things are taking too much time, that's how I would basically judge our success of the investments. And again, as I mentioned in my first point, this isn't about big investments. All of these tools are available out there or open source. So it's more about like how many tokens do you use almost, right? So yeah, in essence, I would say that it's about showing the significant improvement of efficiency of processes and taking out as much friction as possible.
Thank you. I think in the interest of time, I think this would end the Q&A with the speakers on the panel. I'd like to open the last question in the chat, from another anonymous attendee to the entire panel. And the question is really, technology can be deployed relatively quickly, but changing how lawyers actually work is much harder. What has been the biggest barrier to AI adoption within your team's technology, trust, skills, or culture? And I think all of us are probably seeing that in practice. You can see the younger lawyers, AI savvy, and the older ones and different generation, the generation X, Y, Z, and alpha and beta and all that thing, and those from the early generations. So what do you think would be the biggest barrier stopping especially the older and earlier generations, the older generation from adopting? Is there anybody in the panel here who would like to attempt this question? It can be a general question to everyone. What about you, Hofu?
Yeah, I think, ultimately attitude is not really about age. If you want to solve a problem and, you're determined to do it, you find AI to be a really good ally. This is what Frederick said, it makes, the tools make programming so much easier. Yeah.
Okay. Is there any other question from the audience which you would like to pose to the various panelists here? If not, I have a question myself. And the question here really is in relation to AI, right? Does it really empower or disempower the professionals who is using it, and especially in the legal industry? And when we do have access to all these technology, obviously it does, shorten the turnaround time and all that thing. How would that impact? How would the corporate or the clients feel about the basis of, how do you estimate the value of legal work? I think the question is quite important. Is there any views I could get from my panelists? Perhaps from Clarice, Joanne, Louis, are you there?
Yeah, hi. Yeah, I have some views on that. I think a lot of clients ask us sometimes when they see the bill and it's very long, many time entries, then they'll be like, oh, have you used AI, So there is an expectation that the time cost would be reduced if you use AI, and it's a very real one. Sometimes they would also compare against what kind of AI tools you use because they themselves are using some of these tools. So Harvey is obviously like the creme de la creme for corporate work. And yeah, and sometimes they just compare. So for those of us who are using Copilot, I'm not sure whether it's viewed as very atas, like exceptional, so to speak. Yeah, so it's an expectation right now. Yeah.
Okay, thank you. And perhaps I'll just add one last question, and I might just in the event if and it's quite obvious AI is being deployed by one organization, and you need to interact with another organization, and whilst you're reading their responses, it's quite obvious to you they are using another set of AI. So it's like AI versus AI. How do you deal with a situation like that? I wonder whether, Clemens, do you have any views on this when, whether it's your corporate bankers using AI, and then the opposing side is also using AI, the authorities and the regulators. How do you, because the conversation between two AIs can go on indefinitely, right? How do you put a stop to that, and how do you determine whether which view is the more superior view? Clemens, are you there?
It does. Yes, yes, it does. Having said that, we don't usually use AI to respond to counterparties, but we do have a limited budget that we can get external counsel to respond to to other people's AI, and so that there is some limitation there. Having said that, I mean, jokes aside, Joanne, I think raised a very, very good point, right? Which is everybody's now looking for an edge, and if I could bring in some from the previous question as well, it doesn't mean that lawyers will be disempowered, but there will be certain lawyers that would be able to leverage the technology a lot better than some other lawyers. And so others who used to be very, very good because they were able to, and I'm using even before AI thing, memorize tons of precedent, then realize that, with LexisNexis and Thomson Reuters, so even before AI, but with large data coming in, I'm now no longer as good, right? So the skills that are in demand will keep changing. If there's AI speaking to AI, and then, sorry, I got distracted, but to bring in Joanne's point again, that won't give you any novel arguments. So that won't give you that competitive edge. Because if they are all just trying to scrape what general knowledge is already, then that brings everybody to roughly the same level, which is great if you want to do work and perform in an industry where your services or your goods are commoditized. But if you really want to make a difference, then AI can help you get there, but I don't think AI alone will get you there. So I hope I will never see a day where actually two AI in-house counsels are the one negotiating with each other and then agreeing with each other and saying that they've all made really good points and doesn't end up anywhere productive.
Well, actually, I got one last question, which I'd like to pose to the keynote speaker, Mr. Lyndon Xiao, who has dealt with us in so many different sectors. In cross-border situation, we have a very fragmented regulatory landscape in the governance and also the application for the AI framework. Not only just in AI governance alone, as you mentioned, also things like data protection and the various other reporting requirements like sustainability across the region, where you have taxonomies, which is basically legal terms which may not be fully or understood, in a harmoniously situation, where the standards may vary according to the region. My question to you, Lyndon, do you foresee that such challenges of fragmentation could be overcome and could be so-called reduced so that you can enhance the interoperability and maybe also the coherence of the various standards in all these technological frameworks for companies which are operating on a global scale? Today, every company is operating on a global scale. Nobody just talking about one country. Everybody is global. But the problem is there's so many different standards all over. Can AI help us there? Over to you, Lyndon.
Yeah, thanks for that, Taek Yong. And it's a bit of a difficult question to answer, right? Because I think the devil is in the details, right? you talk about fragmentation, but there are many different kinds of fragmentation, many different degrees of fragmentation. And let's take data protection for example, right? You have the European GDPR, and in Singapore you have the PDPA, and in other jurisdictions you have something else, right? So in an organization like mine, to the extent that we have to deal and reckon with, say, the GDPR, I think the usefulness of AI is to to the extent that we don't fully understand the GDPR, helps us to sort of chart out what are the similarities, differences, and do it in a way that perhaps would help us to reduce reliance on external counsel. But I think that reduction can only be to a certain extent, right? And the reason why I say this is because it goes back to what I said earlier in my presentation, as well as points that some of the other panelists have touched on, which is about the stakes of what you're dealing with. So you know that in the event of a data breach, and defined under whichever relevant law, the potential consequences are very, very severe, right? So, I mean, to answer your question directly, I think AI can help us get there, get some ways there. But at the end of the day, if you need a definitive answer, as we often do in our line of work, you can't really shy away from getting the experts in. And on your broader question on whether it will help us resolve fragmentation generally, I think that's really an open question, as to whether we see actually more convergence or divergence. I think we're at an inflection point. It can go either way.
Okay, thank you very much, Lyndon. And with that, ladies and gentlemen, I think it is timely for me to call an end to the session here. So what we have heard today is that legal AI is not one problem. It is a chain of questions. So Joanne reminded us that a plausible AI answer is not the same as a defensible legal outcome. Ho-Fu showed that lawyers need more than access to AI. They need the literacy to understand and interrogate it. Clemens drew the critical distinction between individual adoption and institutional readiness, and reminded us that human oversight only works when the human has the competence and authority to challenge the machine. Fred then brought us to implementation. Start with the process, the data, the playbooks, and the guardrails, not simply another AI product. And Lyndon has delivered a very, very insightful keynote that addresses all these issues in a very holistic manner. So the strategic question for legal leaders is therefore not how much AI we can use. It is where we can responsibly rely on it, and how we preserve human judgment and accountability while capturing its value. So ladies and gentlemen, thank you very much for spending your time and afternoon. It's a Friday, I understand, and different time zones. So on behalf of Tech Summit and the Legal Tech and Document Automation Summit, thank you to all our speakers and to everyone who joined us today. And please continue to connect with us at our various LinkedIn accounts, and to follow the Tech Summit and also our respective social media if possible. And we'll continue our conversation. It's not the end yet. It's ongoing and it's still in the middle of everything. Thank you very much. Have a very good afternoon, and thank you much, everybody. Thank you.
Thank you. Take care.